If you are watching this, you may be dealing with the worst phone call of your life. And I'm going to be direct with you because families deserve the truth in moments like this. In a Florida wrongful death case, you can have a legitimate claim and still lose it for one simple reason. You moved too slowly, or you did not lock down proof before it disappeared. I am Doug Burnetti, founding member of Burnetti PA. For over 30 years, I have represented Florida families in wrongful death cases. The steps I am about to share are the same steps we use to protect families from day one. With 4 steps you must take to give your family the best chance at justice and at a recovery that actually covers what this loss has done. And stay with me to step 4 because that is where many families accidentally destroy their claim without realizing it. Step 1. Secure and preserve every piece of evidence. The first step is evidence, not feelings, not assumptions, proof. Because evidence fades fast. Video footage gets recorded over, vehicles get repaired or sold, equipment gets moved, witnesses forget details, companies lose documents. Sometimes it is innocent, sometimes it is not. If your loved one passed in a crash, you want photos and video of the scene, the vehicle, skid marks, debris, and signage. You also want the name and phone numbers of the witnesses, not just someone saw it. You need the actual information. If it happened at a business, a work site, a hotel, an apartment complex, or a nursing home, ask immediately about security cameras. Do not assume it will be saved. Many systems overwrite automatically. If it is a medical case, preserve everything you can. Discharge papers, prescriptions, test results, appointment notes, messages, even a written timeline of what happened and when. And here is something that most people do not realize. The police report is important, but it is not the full story. I have handled cases where the report missed a key fact, like that a light was out, a sign that was missing, or a witness the officer never spoke to. When we investigated early, we found the detail that changed the entire case, and that's happened many times. This is also where a lawyer can protect you immediately. One of the first things we do is send what is commonly called a preservation letter. It is a formal notice telling the other side to preserve data like vehicle data, phone records, maintenance logs, and surveillance footage. Because once evidence is gone, you are not just missing details, you are missing leverage. Here's a quick example. We represented a family after a tragedy at a construction site. The family had the presence of mind to take photos of the equipment and work area. We sent preservation letters right away. That is how we uncovered a missing safety guard, and that detail became the turning point in the case. Step 2, document every loss and expense, not just the big ones. The second step is documenting damages. In Florida, wrongful death damages can include far more than funeral expenses, but you have to prove what the loss actually did to the family. Start with the obvious, funeral and burial expenses. Save every receipt and invoice. Then go deeper. If your loved one provided income, benefits, or support, gather tax returns, pay stubs, and benefit statements. Think health insurance, retirement, bonuses, and even the value of services provided around the home. Also document the expenses that show up because life does not stop just because you are grieving. Travel for family, hotel stays, childcare, and other out-of-pocket costs can matter. Now let's talk about the part insurance companies love to minimize, the human loss. Your grief is not a spreadsheet, but you should still document it. Keep a simple journal, nothing fancy, just a daily or weekly record of what has changed, how your sleep's affected, anxiety, missed milestones, how the loss is affecting your children, or what your loved one would have been there for. I've seen families walk into mediation with a journal like that, and suddenly the other side cannot pretend this is just numbers. One mother we represented after a boating death wrote down what her kids were dealing with day by day, nightmares, grade slipping, milestones without their parent. That journal made the reality impossible to ignore. Step 3 is about accountability, and this is where a lot of money gets left on the table because it is not always just the driver or the employee who caused the death. In a truck case, the trucking company may share responsibility. So might a maintenance provider. So might a broker, a shipper, or a manufacturer if a part failed. In premises cases, it could be the property owner, the management company, or a contractor or security company. In medical cases, it could involve the physician, the hospital, a staffing company, or a facility system issue. If you only pursue the obvious defendant, you end up being capped by a single insurance policy, even though other parties and other coverage might exist. Florida also allows fault to be divided among multiple parties. That means the defense will often try to shift blame to someone else, including the person who passed away. That is why investigation matters. Reports are a start, not the finish. We use records, subpoenas, sworn testimony, and experts when needed, like accident reconstruction and engineering experts, to find out what really happened. Another real example, we handle a case involving a fatality in a multi-vehicle crash where the initial blame went to one driver. Our investigation uncovered more, a roadway issue, a commercial vehicle factor that contributed to the chain reaction. Identifying all responsible parties changed the recovery and helped the family protect their future. Now, this is the step that can quietly ruin a good case. Florida wrongful death claims have deadlines. Miss the deadline and the court can dismiss the case no matter how strong the facts are. Also, Florida wrongful death cases have a filing requirement many families do not know about. Under Florida's wrongful death law, the case is typically brought by the personal representative of the estate on behalf of the survivors. In plain English, that means there is a legal process that often needs to happen in probate so that the right person can legally file the claim. If you wait too long to start, you can end up racing two clocks at once: the lawsuit deadline and the estate process. While this is happening, insurance companies are not waiting. Adjusters may ask for recorded statements. They may offer an early settlement that sounds helpful, especially when bills are piling up. But early offers are often designed to close the case before the full picture is clear. Here's the rule I want you to remember. Do not sign anything and do not give a recorded statement without legal advice. And do not assume you can handle it later. Later is where evidence disappears and deadlines sneak up. Let us recap the 4 steps to win a wrongful death claim in Florida. 1. Secure and preserve all critical evidence immediately. 2. Document every loss and expense, including the day-to-day human impact. 3. Identify all responsible parties and insurance coverage. 4. Act quickly to protect your rights, set up the estate properly, and avoid deadline disasters. If you are dealing with a wrongful death, you do not need more stress. You need a plan, and you need to move early enough that you are not fighting with one hand tied behind your back. In addition to practicing this type of law for over 30 years, I also experienced a wrongful death myself. My father was killed in an auto accident with a commercial vehicle. So I've been there, and I understand these issues. If this helped, watch my next video, What to Do Immediately After a Truck Accident in Florida. Truck cases move fast, the trucking company responds immediately, and there are several critical mistakes that can cost you and your claim in the first 24 hours. Watch the next video and protect yourself day one. See you there.